Good afternoon, everyone. If you are here to learn about juvenile justice data, trends, and opportunities for improvement, I've got good news for you. You are in the right place. My name is Melissa Threadgill. I'm the Director of Strategic Innovation at the Massachusetts Office of the Child Advocate. And I'll be joined with my co-presenter and colleague today, Christy Palazzano, who's our Juvenile Justice Program Manager. Thank you all so much for joining us today. Before we dive in, a few housekeeping items. First, this webinar is being recorded. Hopefully you got the Zoom notification when you logged in, but this serves as your notice that this is being recorded. The reason we're doing that is we're going to be putting this webinar up on YouTube afterwards. So if anyone missed it, they'll have that opportunity to see it. And if you come away from this webinar thinking it is just the best thing you've ever seen, I hope you'll share the link with your colleagues and friends. We ask that you remain muted throughout. If you forget, Morgan here, our colleague, will be furiously figuring out who's making the noise to mute you, but easier for everybody if you go ahead and mute yourself, like we just learned right there. You will receive copies of the slide at the end if you registered via email. We'll be emailing those out to you. I'm sure we're going to get a question about it in the chat later for someone that's still logging on, and so I'll repeat it, but yes, you will receive copies of the slide. And then finally, we have left some time for questions and discussion at the end. Please feel free to go ahead and put your questions in the chat. I know sometimes as I'm hearing a presentation, I'll think of something and then forget it later. As you think of it, just put it in the chat. We'll keep track of it and we'll answer the questions in order they were received at the end of the presentation. So with that, Christy, if you'd like to go ahead and start sharing the screen, we will begin the presentation. Great. All right, if you want to go to the next slide. So all of us are gonna be talking about a couple things today. We'll start with a quick briefer on the Office of the Child Advocate. I'll go ahead and get a mute on that. Okay, great, thank you. Okay, so we will talk briefly just about the OCA and who we are, as well as the Juvenile Justice Policy and Data Board, if you're not familiar with our work. The bulk of our presentation will be focused on going through key data findings from the board's annual report, which came out in January and was focused on from our work in 2022. We're also going to mix in some findings from a brief that we put out focused on racial and ethnic disparities as well. Then we're going to talk about some opportunities for improvement that we see sort of based on the data analysis. We'll do a quick summary of JPAD's work from 2022, and then we'll have some time for questions and answers. So just briefly, in case you don't know who we are, the Office of the Child Advocate is an independent executive branch agency that provides oversight of state services for kids. We look at services for children across the spectrum of things that are provided by the state, with a particular focus on ensuring sort of appropriate, timely, and quality state services, and that the Commonwealth's most vulnerable and at-risk children have the opportunity to thrive. One of the many things that the OCA does is chair the Juvenile Justice Policy and Data Board, which is what brings us here to you today. The Juvenile Justice Policy and Data Board was created as a permanent commission by the legislature in 2018 as part of the Criminal Justice Reform Act. Our membership is set by statute, and it consists of representatives from child-serving agencies, from the executive and judicial branch, as well as members of the State House and Senate, representatives from some advocacy organizations, as well as a parent representative. The legislature gave us a number of tasks. We are charged with evaluating changes in juvenile justice system policy and procedures and making recommendations for further improvement and outcome. We are specifically tasked with collecting and reporting available aggregate juvenile justice system data. We're asked to look at the implementation of any statutory changes to ensure that the sort of goals of the legislation are being met in implementation. And more broadly, we're asked to make recommendations for any statutory changes that we think would improve the juvenile justice system. Next slide. So before we dig into the data, which I know is what everyone's here for today, I just want to do a quick overview of sort of what we think of as the typical juvenile justice process. Now, I know some of you, just looking at the names and faces in this group, some of you, practice in the courtroom. This is going to be extremely familiar to you. Other folks might not have quite as much familiarity with all the nitty-gritty steps of the justice system process. And so I just wanted to quickly walk you through this so that you've got an understanding of the terms that we use. We say the typical process because it's important to note that at each of these stages, youth sort of are diverted or dismissed, and so they end up on another track. Not every youth goes through each of these steps, but these are the steps sort of for the full process. So it starts with an alleged delinquent offense, which leads to some form of law enforcement contact. That contact could result in an arrest of the youth, and that sort of, sometimes we'll refer to that as a custodial arrest. That's sort of exactly what you might think of: handcuffs, back of the police car, the youth brought back to the police station. That law enforcement contact can also result in a summons to court. And so in that case, the youth does not go through a custodial arrest, but instead is told they need to come to the court at a future date to answer the summons. After that law enforcement contact, that complaint is brought to the juvenile court. That results in what's called an application for complaint. And we really think of that as the front door of the system. It's where all of the complaints are coming to the court to be processed. That complaint goes through a review by the court clerk, and that can, but not always, result in a delinquency filing. From there, the prosecutor makes a decision about whether or not to bring charges, and if so, that will result in what's called an arraignment. We think of the arraignment as a particularly important event in the life of a case. It's really where the sort of court process heats up. A youth might be brought into the court for a hearing with a judge, pretrial conditions are set, and it's also the point at which the offense will appear on a youth's record in the future. The fact that they are arraigned, even if they're later found to be not delinquent, that arraignment will appear on the record. Following an arraignment, there can be any number of pretrial proceedings that might include a hearing on dangerousness. It could result in a youth being held pretrial or being placed on pretrial supervision. Following that, at some point, there will either be a trial or the case could result in a plea. And that leads to what's called a fact-finding disposition. In adult court, we might think of this as were you found guilty or not guilty. In the juvenile court, we sort of refer to it as delinquent, not delinquent, or a case can also be continued without a finding. Finally, the results in a potential sanction, which again, in adult court, we sort of refer to as sentencing. And that sanction might include being placed on probation, being committed to the Department of Youth Services, or a combination of being committed to the Department of Youth Services and to adult prison for a small subset of offenses. So finally, it's really important to point out, thank you for that addition, Christy. We will talk about opportunities for diversion a lot in this presentation. Diversion is typically thought of as occurring pre-arraignment. And so we really look at these law enforcement contacts as well as the early stages of the court process as the opportunities at which a diversion could occur. All right, next slide. All right, so I'm going to talk to you just a big picture about the trends that we're seeing. I'm then going to turn it over to Christy, who's going to talk about these trends in more detail. But I always like to give you a little road post of here's where we're going with the presentation. So first, we're going to talk about 3 trends in system use. One major trend that we discovered in the data this year is that there was an increase in use of the juvenile justice system across process points from fiscal year 21 to fiscal year 22. If you're not familiar with state fiscal years, this is basically July 1st through June 30th. And so what we're looking at here is June 30th, 2020 through June 30th, 2022. I always get those ones screwed up. So basically data ending as of end of last June, excuse me. So we saw an increase over the course of that year, and that increase was driven in part by an increase in youth that were alleged of committing person, weapons, and property offenses. I think weapons and property offenses are pretty self-explanatory. Person is usually considered sort of a violent crime, something like assault and battery. However, compared to prior to the pandemic, we see that overall system use is still declining, particularly when we look back to 2018. And this is because we saw a big drop in the use of the system following the 2018 Criminal Justice Reform Act. And over time, despite the increase in the past year, we're still seeing that overall decline from years prior. Finally, most youth delinquency cases are dismissed or diverted and therefore do not result in a trial or plea. So Christy, if you want to go back one slide. Oh, I'm really screwing this up for you because of the animation. So you see sort of towards the end, this trial plea step. The vast majority of cases do never ever make it to that point. They are either dismissed or diverted before the case reaches that process. And that has been a trend for at least the last couple of years when we've had data. I suspect even before we had data that it was a trend. So it's not new, but it is something really worth pointing out because I don't think many folks that only have a casual understanding of the system realize that that is how most cases result. All right. So now we also looked at trends into who comes in contact with the juvenile justice system. So a first major trend is that Black and Latino youth are overrepresented at every single stage of the process. This is unfortunately not a new trend, but it is an important finding in the data that we want to make sure that we highlight. This year, we are also able to look at youth with who have involvement with the Department of Children and Families. We only have data on youth who are detained or committed to DYS, so we're only able to look at it those process points, but we find at those process points that youth with DCF involvement are also overrepresented. A second trend in terms of who comes into contact is that a majority of youth entering the system are alleged of misdemeanor and or nonviolent offenses. And again, this has been a trend for many years, I suspect possibly all of the years. And it's important to note this because, as we said, although we're seeing an increase in the last fiscal year of person and weapons offenses, that can sound a little scary. Oh my goodness, what's going on? Although we are seeing that trend, it's always important to take a step back and remember that the vast majority of kids entering the system are really coming for much lower level offenses. And then finally, as we look at particularly at the data of youth who remain in the system, and so again, looking at data on youth who are committed or detained with the Department of Youth Services, we see that many youth have significant and potentially unmet underlying needs that could have been driving the delinquency system involvement. So whether that's educational needs or substance use or mental health needs or prior history of trauma, we see that the kids that remain in the system have very, very significant needs. All right, next slide. And then finally, after Christy walks you through the data in some more detail, we're going to talk about a couple of key opportunities for improvement that were identified in this year's report. We're not going to highlight every opportunity for improvement, but we really wanted to pick out three major ones that we thought were representative and that we could sort of demonstrate the connection to the data that we're going to discuss. So first is that there remain many opportunities to increase the use of diversion, particularly as we look at the rates of disproportionality for youth of color, youth with child welfare system involvement, and youth who have unmet needs. Second, as we do see this uptick in the previous fiscal year and youth coming into contact with the system, we really want to think about how can we increase support for programs and services that promote social connectedness and positive youth development and ultimately can help prevent delinquency. And then three, we're going to talk a little bit more about the particular racial and ethnic disparities we see at the front door of the system, so at the point of arrest. And we're going to talk about ways that we think police departments could provide more guidance and limitations on when to use a custodial arrest, when to issue a summons, and when to offer diversion. So with that, I'm now going to turn it over to Christy, who's going to walk you through the data in much more detail. Thank you.
Thanks, Melissa. Good afternoon, everyone. Thank you so much for joining us. As Melissa mentioned, my name is Christy Palazzano. I am the Juvenile Justice Program Manager here at the Office of the Child Advocate. I'm going to go over the high-level takeaways that Melissa just described in those first two slides, the data for those takeaways. If you have questions, I'm going to go through this data fairly quickly. So if you have questions, as Melissa mentioned, you will get these slides afterwards, but feel free to pop your questions in the chat and we'll be sure to answer as many as we can at the end of the presentation. So without further ado, a little bit of an introduction here. So a lot of the trends that we're going to go over follow a similar pattern to arraignments, which are presented on this slide right here. So there's a similar pattern in system use across all process points over the past 5 or so years. So for example, these are arraignments from fiscal year 2018 through fiscal year 2022 last year. And basically what we see in the data that there was an initial decline in fiscal year 2018 that can largely be attributed largely to the Criminal Justice Reform Act, which was implemented in 2018. After that, we see a continued decline, and specifically in between for fiscal years 20 and 21, which is when the COVID-19 pandemic initially started and the emergency response. And we'll go into a bit of that detail in a couple slides and how that impacted the system. And then we see this increase between fiscal year 21 and fiscal year 22 that we're going to go over. We attribute much of that increase to the COVID-19 pandemic. But when we look at fiscal year 2022 compared to 1 year pre-pandemic, so fiscal year 2019, we see that overall system use is still down compared to pre-pandemic numbers. So for example, for arraignment use, the number of arraignments are down 11% in fiscal year 22 compared to fiscal year 2019. So again, this was just one example and one process point, but remember that this pattern, we see this across process points as we dive into some more of the data here. So like we've been mentioning, there was an increase in juvenile justice system use between fiscal year 21 and fiscal year 22. This ranges from a 10% increase in overnight arrest admissions through 61% in first-time commitments. So across the bottom of this graph are all different process points in the juvenile justice system, and you could see each one had an increase in system use over the last fiscal year. Except for the average pretrial probation caseload, we saw those numbers decrease slightly in this last fiscal year. Excuse me. So we think this increase in juvenile justice system use in fiscal year 22 can likely be attributed to the pandemic, and we think this for a number of reasons. First being, during the height of the pandemic, numbers were extremely low, and in some cases at all-time lows in system use. And this is for a number of reasons. One, under individual and societal factors, many of us were at home, many youth were at home isolating and away from peers and school and places where generally kids are being, might be involved in delinquent offenses. There was also a systemic response during the pandemic. There was a concerted effort by juvenile justice actors to keep youth out of the juvenile justice system, and specifically custodial settings. We knew that kids in detention or in residential settings were at a higher risk for contracting COVID. And so there was a concerted effort to keep many kids who didn't need to be there out of those settings. That drove those numbers down throughout fiscal year 20 and 21. So then we see in fiscal year 22, as numbers start to increase, this happens for a number of reasons. So again, there were individual and societal factors that came along with that. So for example, the trauma that youth went through, that we all went through going through the pandemic, but specifically kids had a very tough time. And we could see that in their behaviors as youth are returning back to school and back out more in public. There's an increase in delinquent behavior as a result of the trauma experienced in the pandemic. Also, there's been a systemic response as courts have started opening back up. Many of the cases that were paused because they were not emergency responses throughout the pandemic are now being heard. So we see this backlog of cases starting to move through the system, which is contributing to an increase that we see in fiscal year 2022. So a number of reasons why we think the pandemic, we can really see the impact of the pandemic in the numbers that we're about to present. So we'll go through the reasons why youth are coming to the system. But before we do that, it's important to know that youth may be involved in the juvenile justice system for a variety of reasons. So right here, this chart shows examples of common offenses youth in the juvenile justice system could commit. So everything in purple here is an offense type. That's person, property offenses, motor vehicle offenses, weapons offenses, drug and alcohol offenses, and public order offenses. Underneath each category are specific crimes that you likely have heard of that fall within those larger categories. Offense categories can also be classified based on the severity of the offense. And you'll hear us throughout this presentation talk about misdemeanors, which are generally thought of as less serious or less severe delinquent offenses, as well as felonies, which are generally more serious or more severe types of offenses. So for example, a misdemeanor could be trespassing, and a felony would be something like armed robbery. So when we look specifically at the changes in fiscal 2022 that we saw, the increase in system use, we saw the increase in system use was primarily driven by an increase in youth alleged of committing persons, weapons, and property offenses, like Melissa mentioned early on. So in this red box here are those offense types, and you could see we saw an increase across offense types, except for drug offenses were down. But really, when you look at the number of offenses, the increase in the number of offenses, you could see that person offenses, there was over 1,600 additional applications for a complaint in fiscal year 22 compared to 2021, 463 more applications for complaint for property offenses, and 320 more applications for complaint for youth alleged of weapons offenses in fiscal year 22 compared to fiscal year 21. So those are really the offense types that are driving this increase in system use for last fiscal year. But like I just mentioned, when COVID had a big impact on the system, and so when we look at these numbers compared to, or when we look at system use compared to fiscal year 19, which was 1 year pre-pandemic, we see there's a little bit more to the story here. So compared to pre-pandemic numbers, overall system use is still declining, but specifically at deeper system process points and for misdemeanor offenses, so for those lower severity offenses. So when we look at the process points after arraignments, like Melissa mentioned earlier on, which is when we think of a very important process point in the juvenile justice system, when youth officially get a record and are officially charged with a delinquent offense at that arraignment stage and afterwards, we see a deeper decline in system use compared to pre-pandemic numbers, and specifically for misdemeanor offenses, those lower severity offenses. So the purple bar charts here represent the change in misdemeanor offenses in fiscal year 22 compared to fiscal year 2019. And the blue here are felony offenses. So this continues a trend that we saw since the implementation of the Criminal Justice Reform Act in 2018. So as a refresher for some and maybe some new information for others, in 2018, the Massachusetts State Legislature passed the Criminal Justice Reform Act, the goal of which was to reduce the number of incidents resulting from children's unlawful or problematic behavior that results in a response from the juvenile justice system. So limiting the number of youth that are coming into contact with the juvenile court. It did a number of things specifically for the juvenile justice system, had a number of provisions like raising the age from juvenile court jurisdiction from 7 to 12. It removed the juvenile court jurisdiction for some first-time lower level offenses. It allowed judges and for judicial diversion pre-arraignment. It had some requirements around school resource officers and police and school districts. And it revised some of the processes around overnight arrest. And we could see that this law had an impact in the data. So when we look at the fiscal year 22 data compared to fiscal year 2018, which was when the law was implemented, we can see that process points are down across the board, across most process points, except for pretrial probation caseloads are slightly up. So this ranges between 12%, a decline in 12% use of court summons through 59% in overnight arrest admissions. We could see that across the board. So even though there's been an increase between fiscal year 21 and 22 in system use, we do see a decline when we're looking at a little bit longer trends since the Criminal Justice Reform Act was implemented in 2018. The board's final takeaway that Melissa highlighted early on was that system use regarding system use was that most youth delinquency cases are still dismissed or diverted and therefore do not result in a trial or plea. This is a trend we've seen over the past 5 years, and like Melissa mentioned, we suspect has been happening beyond that, perhaps. So this chart shows the numbers of each juvenile court process point that Melissa went over earlier on. So for example, you could see in 2022, there was over 8,800 applications for complaint, 5,498 delinquency filings, over 3,000 arraignments, about 1,200 fact-finding hearings or dispositions, and 454 cases where youth were adjudicated delinquent, which is what we call found guilty in the juvenile court. So you can see here that many cases don't make it to that fact-finding disposition or a trial, or are not resolved through a trial or a plea. In fact, about 3/4 of delinquency filings don't make it to a fact-finding disposition, and more than half of arraignments aren't making it to a fact-finding disposition. So that's a little bit about the system use and the high-level takeaways about system use in Massachusetts over the past year and over the past 5 years. I'm going to turn to some data around youth who are in the system. So these are youth who are still coming into contact with the state's juvenile justice system. So as Melissa mentioned, one of the board's takeaways since we've been, since our inception has been that racial disparities remain a significant problem. So these are some real quick data points here. I'll dive deeper into it. But some things that we found specifically in fiscal year 22, when we looked at the data, was that the increase in juvenile justice system use for this year was driven largely by an increase in admissions for Black and Latino youth across process points. Although most race categories saw an increase in system use, for all race categories, Black and Latino youth had higher rates of involvement over the past year. On average, Black and Latino youth stayed in detention longer than white youth. So Black and Latino youth on average spent about 66 days in detained pre-trial compared to white youth who spent on average 53 days in detention. Of the youth who are detained pre-trial, Black and Latino youth often had their cash bail set at higher rates above $500 than white youth who were detained on cash bail. And white youth, we'll go over this data in a little bit, white youth are being diverted or their cases are being dismissed more frequently pre-arraignment than Black and Latino youth. And again, the board uses arraignment as a particularly important juvenile justice process point. When we dig into the data, something the board has found is that for several years now, the racial and ethnic disparities in our system are particularly high at the front door of the system. So when we say front door of the system, we're talking about the application for a complaint stage, the arrest stage, or the application for a complaint stage, and whether youth are arriving at court as a result of a summons or due to an arrest or a custodial arrest. So compared to their white peers in Massachusetts, Black youth were 3 times more likely to be the subject of an application for complaint in fiscal year 22, and about 5 times more likely to be arrested compared to white youth in Massachusetts. Latino youth were about 2 times more likely to be the subject of an application for complaint and 3 times more likely to be arrested compared to white youth in Massachusetts. So these disparities are particularly high, as I mentioned, at this front door. And so the board this past year in fall wanted to dig a little bit deeper into the data at these stages, excuse me, in order to start to think about what we can do to reverse these trends. So we wrote a whole report outlining this data, and Morgan, if you want to, I see you just already dropped the link into the chat, dig into the data more, but we'll provide a high summary here. So we tested 4 hypotheses with the data that we had, specifically looking at kids coming to the system, whether it was on an arrest, again, thinking about what you generally think of around a custodial arrest, a physical arrest, so handcuffs, a police cruiser, things like that, versus a court summons. These hypotheses here come from the Federal Juvenile Justice Department, called the Office of the Juvenile Delinquency and Prevention, OJJDP. So we tested 4 different hypotheses. So we wondered what accounts for the racial and ethnic disparities in the juvenile justice system. Does it have something to do with offense types? So are youth of color brought to court for offense types that are more likely to result in arrest because they threaten public safety, like weapons offenses or persons offenses? We also tested hypotheses around offense severity. So are youth of color brought to court for more serious crimes than white youth? We tested hypotheses around geography. So an example would be that some police departments are more likely to use arrests compared to summons or even to diverting youth than others. And those might be the same police departments that and jurisdictions that have a higher percentage of youth of color, and that's what's causing these statewide disparities. And we also, it was a little bit tougher to measure, but looked at national research around police practice to test whether, police practice has something to do with racial and ethnic disparities, such as police officers might be more likely to arrest, more likely to use an arrest compared to a summons or diversion for Black and Latino youth rather than white youth. And we looked at certain police practices, for example, like hotspot policing that concentrates resources in certain neighborhoods to see if that might be impacting the disparities that we see in the data. So like I said, we dive into this in a full report. And if you're into the wonky weeds data, you should definitely check that out. But basically what we found that each of these 4 hypotheses can account for some, but not all of the differences that we see in disparities between the number of Black and Latino youth coming into contact with the juvenile justice system and white youth coming into contact with the system. So for example, around offense type and offense severity, Black and Latino youth did have higher rates of arrest for more serious offenses, but they also had higher rates of arrest for misdemeanor offenses or lower level offenses. So we see that those higher level offense types did account for some of the reasons that we saw disparities in the data, but not all of them. So Melissa will dive into this in a little bit, but this report also offers recommendations to address the disparities that we see across multiple levels that we tested through these hypotheses. So they go into investing in prevention and alternatives to arrest, gathering and using data to spot problem areas, specifically at the police department level and not the statewide or county level data, county level. And then our third recommendations fall into reducing disparities through changing specific policy and practices around maybe when to issue more guidance around when to issue arrests versus summons. So shifting back to other groups of youth that are overrepresented in our juvenile justice system for fiscal year 22, this chart here breaks down detention admissions. So youth who are detained pre-trial by their child welfare in Massachusetts, that's through the Department of Children and Families, or DCF. And you could see the blue part of this pie chart are youth with DCF involvement at the time of their detention admission, and that's 50% of kids who are detained pre-trial. So youth with DCF involvement spent on average 6 more days in detention compared to overall admissions. Compared to youth detained without DCF involvement, youth with DCF involvement had a greater percentage of those youth are held on cash bail, and a greater percentage are held on lower level offenses. In addition to the racial and ethnic disparities and the overrepresentation of youth with child welfare involvement, we also see that many youth who remain in the system have significant and potentially unmet underlying needs driving their delinquency system involvement. So for youth who are detained pre-trial, we saw significant educational needs, past traumas that may or may not have been addressed and contributing to their delinquent behavior, as well as mental and behavioral health needs. So for example, more than half of youth detained pre-trial had an IEP or an individualized education plan, which is twice the rate of Massachusetts students generally. A quarter of youth detained pre-trial had previously experienced physical or sexual abuse or had been sexually exploited. And about a third of youth detained had identified feelings of depression or anxiety, which is almost twice the rate of Massachusetts youth population. So a significant amount of needs here that may or may not have been met and may or may not have been contributing to their delinquency behavior. Finally, a finding that the board has had over the past couple of years is that despite that original chart that I showed about how many cases were being diverted or dismissed, a majority of youth entering the system and a significant portion of process points after that, later on in the system, are there for alleged misdemeanor or nonviolent offenses. So this chart here breaks down the different juvenile court process points. The blue here represents felony, so those more serious, more severe offenses, and purple represents misdemeanor or lower level offenses. And you can see while earlier on, the purple here, so misdemeanor offenses represents almost 60% of all cases, that does taper off a bit as you get deeper into the system, which is generally a positive thing the board has found. There's still a significant amount of kids who are coming into, who are being arraigned, who are there for lower level or misdemeanor offenses. So almost a third of all arraignments in fiscal year 22 were there, were being arraigned for misdemeanor or lower level offenses. So that's the high level overview of the data. I'm going to pass it back to you, Melissa, to go over opportunities for state improvement.
Great, thanks, Christy. That was a lot of data, and believe it or not, just the tip of the iceberg of the data that is available in our 100+ page annual report. I'm going to start talking a little bit about some opportunities we see based on the data. So if you have remaining data questions we didn't answer, this is a good time to go ahead and pop those into the chat, and we'll get to this. So first, we find that there remain many opportunities to increase the use of diversion. And this is a complicated one. I want to talk it through a little bit. So first, our pitch for diversion. Diversion has been very well studied through a number of rigorous academic research across the country. A lot of studies on this. And what the research finds is that when you compare youth that were diverted to those that were formally processed through the juvenile justice system, we see that youth who were diverted report less exposure to violence, they have higher rates of school enrollment, and they have higher perceptions of their own future opportunities. And they're also, and this is important, they were actually less likely to be rearrested. So whether you're focused on the impact on the youth themselves, or you're focused on public safety, or you're focused on both, a lot of really good support for the youth diversion. So Christy just went through data on youth that we see that are overrepresented in the juvenile justice system. Black and Latino youth, youth with DCF involvement, youth with unmet needs, and youth with lower level offenses. And we sort of see that there's opportunities for all youth, but particularly for these groups where we see disproportionality, to consider, is there more opportunity for diversion? So if you want to go to the next slide, Christy. So you've seen this slide before. This slide is both a good news slide and a slide for future questions. So the good news is the vast majority of kids that are coming in through the juvenile court, through the application for complaint process, are being filtered out in one way, shape, or form. They might be formally diverted, they might be more informally diverted, or they might simply have their case dismissed. That's really, really quite good news. However, we also see that there are still about 3,000 arraignments in fiscal year 22. The majority, so 59% of those, do not ever lead to a fact-finding disposition. The youth was never found delinquent or not delinquent. There wasn't a quaff. So again, it's well over 1,000 cases that are dropping off sometime between the point of arraignment and a disposition. And there's any number of reasons that can happen. There can be issues with evidence. Witnesses may decide they're not willing to testify. The prosecutor may realize that they don't have a sufficient case. Evidence can be suppressed. Lots of things that can happen. But still, some number of these cases are being dismissed, and it's not clear to us that all of them are for evidentiary reasons, which suggests that there might be more opportunities to divert youth prior to the arraignment, prior to ever reaching this stage. We also, even just looking at the difference between the number of applications for complaint and delinquency filings, that's several thousand cases. Could those youth have been diverted by law enforcement prior to ever coming to the court, is an open question we have. A second question we have is, are certain categories of youth being overlooked for diversion opportunities more often, particularly at earlier process points? And so what I'm going to show here is some data on racial disparities in when youth see their case dismissed. So what we see in the data is that white youth are being diverted or having their case dismissed more frequently prior to arraignment, compared to Black and Latino youth who have higher rates of case dismissal post-arraignment. So if you look at this chart here, yep, the little red circle there, that shows you that 87% of applications for complaint for white youth are dismissed or diverted prior to a plea or trial. In comparison, that rate is only 80% for Latino youth and only 84% for Black youth. So we see some disparities there. But then when you look at the flip side and you look at the percent of arraignments that, again, there's a sort of drop off between arraignment and a plea or trial, we see that those are actually much more likely to be Black youth. So 66% of the time that happens for Black youth, and Latino youth that happens 58% of the time. And so when I look at this data, what I see is a system that is more likely to dismiss or divert white youth prior to arraignment than Black and Latino youth. It's sort of right there in the data, and it raises the question of, can we be doing better for multiple groups of youth to divert or dismiss earlier in the process? So that's one. Next one. So we've talked a couple times that we are seeing a uptick in youth coming to the juvenile court sort of post-pandemic. And Christy talked through all the reasons why. But when we look at, a number of factors, including, I think, reports of increased behavioral health needs of youth, I don't think a week goes by in the globe that we're not reading stories about that, or challenges within schools, we see that kids are struggling and there's a need for further support. And so if we want this 1 year uptick to be, again, just an uptick and not a trend, we really have to get upstream and focus on delinquency prevention. And so we see a need for increased support, and support means money for programs and services that address delinquency, that support positive youth development, and address those pandemic fueled effects. And in particular, we think about ones that are focused on things like social re-engagement, so peer support and mentorship, school re-engagement and support with academic success, vocational programs, helping youth see sort of opportunities for the future, life skills and civic engagement, as well as safety planning and violence assistance work for some of our sort of gang-involved youth, including credible messenger programs. And then across the board, we see need for enrichment activities, again, to get youth reconnected, engaged in positive activities, and away from delinquent activities. Next slide. So, and this is the data right here. This is the uptick we're talking about. This is this 47% increase in applications for complaint over the last fiscal year. And we would like this to be a blip and not a trend. And that's why we need to get upstream. Next slide. So the last opportunity for improvement that we want to highlight goes back to, Christy was talking about our brief looking at racial and ethnic disparities at the front door. And so Christy, if you want to actually go one slide, I'll come back to this. Just as a reminder, when we look at sort of the way white youth are processed through the system versus Black youth and Latino youth, we can see that white youth are significantly more likely to have their case come to the court through a court summons versus Black and Latino youth, which are more likely to have their case come through with a custodial arrest. Now, when you take a step back and just think about the experience of that youth, right, of being physically arrested versus having a court summons, it is a massive difference in their experience. And so this is right at the front door, a way that we're creating disparities and stress, if not trauma, for youth. And we'd like to see if there's some ways we can work to tackle this front door disparity. And so if you want to go back a slide, Christy. So it is state law that summons is the preferred method for bringing a youth to court. It's in state law. It's in the MPTC training guidelines for police departments. And so we're not sort of asking for anything that isn't kind of already the policy. What we're really trying to do is like, let's push this to make it more specific and more clear about when this should happen. So many police departments include language in their policies that say, we pulled this from one police department, whenever reasonable and possible, an officer will request a summons for a juvenile rather than taking him or her into custody. We think there's an opportunity to be a little bit more explicit in the language and even provide specific examples of the types of offenses that would warrant an immediate custodial arrest versus ones that are really recommended for court summons or even diversion. And we did see some, not a lot, but some police departments that had policies that released a little bit more explicit on that front. We'd like to see more explicit guidance across police departments. So those are just three. There's more in the report, but those, 145, that's about all the time we have to highlight. I'm going to very quickly walk you through a little bit of the other JPAD work. You can consider these teasers. There's more info on our website about all of these, and then we'll move to questions. So real quickly, another major report that the JPAD put out actually in December of this year was focused on the state's child requiring assistance system. It's another long and detailed report, and so lots of opportunities to dig in if you're interested. But just briefly, the CRA system is a system that allows parents and schools to file a petition with the court alleging that a child requires assistance from the state to help address behavioral concerns. These are things like truancy, running away, or repeatedly failing to obey the lawful and reasonable commands of a parent. That is often referred to as a stubborn CRA. This leads to a civil court process, which can involve supervision by the court, typically involving the probation department, referrals for services, and at times it can lead to a change in custody and out-of-home placement through DCF. So next slide. The board did a very long and in-depth study on this, and the big picture highlights are that despite reforms to the system in 2012, for those that were around then, you might remember the CHINS to CRA reform, we find that many problems with the CRA process remain. And in particular, contrary to what many families and even child serving professionals believe, the courts do not have any special access to services to support children. They don't have services that are only available for youth with CRAs. They don't have a magic wand that moves someone up on a wait list. But because so many families are experiencing barriers to accessing supports in the community, they come to the court desperate for help. And so if we're going to really address sort of the challenges in the CRA system, a lot of that is about getting families connected to community-based services and getting them supports earlier so that they don't come to the court in the first place. And so next slide, lots more details in the report, but we made a variety of recommendations with three key themes. One theme is around how can we shift a significant portion of CRA cases from the courtroom to the community. A second theme is if we're going to do that shift, how can we increase the availability of school and community-based services that specifically meet the needs of youth in the CRA system? And then a third theme is just how we can continue to collect data and study these recommendations. All right, last thing I'm going to talk about is diversion, and then we'll turn to questions. For those of you who've been following the JPAD work, you might know that we have been talking about diversion since 2019. It is a big theme with us. And all of the board's work ultimately led to the launch of what is the Massachusetts Youth Diversion Program. This, through generous appropriation from the legislature, is a project that is a partnership between the OCA and the Department of Youth Services. And it is a program that was designed through the JPAD board's work. This program is designed for youth with first-time and or lower-level offenses or cases where the youth's unmet needs may be driving the delinquent behavior. The program will accept referrals from police, clerks, district attorneys, and judges. Anyone who has legal authority to make a diversion referral, we will accept them. The program includes an evidence-based intake and assessment process. The program requirements and services are tailored to the individual needs of the youth. There's no cookie cutter approach here. Every youth gets an individualized case plan, and that case management and diversion services are provided by community-based organizations. We are so happy to say that we're currently operational in 5 counties. We started in 2022 with programs in Middlesex, Essex, and Worcester. This year, we've been able to expand to Hampton and Plymouth counties, which is really exciting. And assuming all things go well in the state budget this year, our hope is to expand it to 2 to 3 additional counties next fiscal year and continue building the program as we go. All right, next slide. We like to track data. We're a big fan, and we want to make sure that we're tracking data just like we're asking other folks in the justice system to track data. So in our first year of operation in 3 counties, we had 134 referrals with 45 graduates, with many more on target to graduate soon. I don't want you to look at that number and think, so wait, did the rest fail? Nope, they were just still in the process of diversion for the most part when we did the data pull at the 1-year mark. I also wanted to pull some data to show you the racial demographics of the youth in the program. We really have been pushing diversion as one way that we can address the persistent racial and ethnic disparities in our justice system. And so it's really important to make sure that youth of color are having opportunities to be diverted. And so I see a lot of hope in this slide and a little bit more work to be done as well. So on the bottom, what you're going to see is the population in 2020 of the general youth population in those 3 counties, so Worcester, Essex, and Middlesex combined. On the second row, you're going to see the demographics of applications for complaint in those counties. And so you can already see right there, we've got some disparities between the youth population and who's being referred to the court. On the top, what you can see is the demographics of youth that are referred to diversion. And so what you can see here, the really good news is that we see that Hispanic or Latino youth make up a really large, actually the sort of the biggest proportion of our diversion referrals, and a bigger proportion actually than applications for complaint in those counties. And so we can see that diversion is being used to reverse some of the significant disparities that we see in the system. And that's really good news. Where we're doing a little bit less well is with Black or African-American youth. Now we're still sort of overperforming, if you will, from the baseline population, but we're a little bit lower than the applications for complaint. Now I want to caution when you're looking at 134 referrals, that is essentially 2 or 3 kids, right? So it's not huge numbers, and that can lead to, small numbers can lead to bigger shifts in percentage. But still, that's something we're keeping an eye on. And if that continues to be a trend, it's something we're going to communicate to referrers is how can we do more to make sure that referrals are coming in an equitable fashion. But for a first year of data, a first crack at it, we need to keep tracking this, but we're seeing some really positive signs. All right. I think the rest of the slides are just links to stuff. You will get a copy of the slides. Why don't we go ahead and turn to questions? Morgan, do you have any teed up for me?
Yes, when we were discussing crossover youth and we were focused on youth that were concurrently involved with DYS and DCF, someone had a question why we don't also look at those who are involved with DMH as well.
Yeah, that's a great question. And I think it is worth looking at. This is a partnership with DYS on this data, and a fair amount of work goes in behind the scenes to do cross matches between youth with DCF involvement and DYS. And Christy, do we know of a particular hurdle to DMH, or is it just something we need to keep working on?
I think that's something we need to keep working on. Specifically, though, when thinking about crossover youth, I think a lot of the national literature points to child welfare involvement specifically, as opposed to residential placement with DMH or something, but definitely something that we'll continue to look into.
Great. We had another question just talking about the differences in referrals on the county level for different diversion programs. And someone is wondering what would folks might attribute that discrepancy to?
Yeah, that's a good question. So one tricky thing with the data is we're always on a delay, right? So this data is fresh as of June 30th, 2022. And we all know that shifts can happen in the system at a little bit of a faster rate than we're able to identify them. So I'm not sure what exactly might be going on in Hampton County. But I think it's important to note that diversion is ultimately a decision that 4 players get to make. Law enforcement, court clerks, district attorneys, and judges all have statutory authority to make diversion decisions. Judges have a few statutory limitations on the charges that they can divert, but ultimately diversion is a decision by the folks with that authority. And so if we're seeing a shift, it might be that folks are using that authority differently. It could be that we're seeing a difference in the types of cases coming in. So if we were seeing a big influx of gun possession charges, for example, typically that is not a case type that folks tend to divert. And so if we were seeing a big shift, that might result in it. But still, I'm not totally sure what that would be leading to the decline for you, so much as it might be leading to a difference in percentage. So that's my best answer for that one. I hope it was helpful. What else do we got?
A few more diversion questions. What counties will the diversion program be expanding to and when?
Oh, this is a great question. So every year, the Department of Youth Services puts out, or every year for the last 2 years, so we're going into year 3, puts out a request for responses. It is an open process. Community-based providers are welcome to apply to be a diversion coordinator provider. We do ask that they have letters of support from people in that county that would make that diversion decision. So like in our last round, for example, we had letters of support from the district attorneys in that county saying, yes, I support this program coming to my county. We've seen letters of support from judges. So I can't tell you what we're going to expand to next year because we haven't run that RFR and we haven't had the applications yet. So this is a great little plug. We're not in the RFR period yet, which means we can answer any and all questions that you might have about the program that would allow you to put together a good application. Once the RFR is launched, we're more limited by procurement rules and what information we can provide. So if you have got thoughts about diversion in your county, reach out and we'll be happy to chat.
All right, thank you. One more diversion question. Do you have any recommendations about how families, providers, etc., could advocate for diversion referrals?
Yeah, that's a really good question. So in many stages in the process, the youth will have an attorney. That's typically, they have access to an attorney through the Committee for Public Counsel Services. Yeah, I'm sure we have some CPCS attorneys on here. Any good CPCS attorney is going to be pushing for diversion, but still, if you know a youth and that's not being put on the table, you should raise that and say, you know, is diversion an option here? If it's a part of the process that is sort of earlier than, you know, maybe the attorney contact hasn't been made, you know, folks could say to law enforcement, do you think diversion could be an option here? And if you're a provider, you might even be able to say, hey, we've got a good program, send us youth, we'd like to work with them. That's on an individual youth level. On a macro level, again, the 4 people that have the authority to make a diversion decision are law enforcement, court clerks, district attorneys, and judges. And so reach out to the folks in your area that make these diversion decisions. District attorneys are elected officials. Law enforcement are sort of typically report up to a mayor. Let them know that you care about diversion, you think it's important, and you'd like to see more of it.
And for our final question, this is more about the data. Has there been any effort among state systems to use the same categories for collecting race data?
Oh, this is a great question. Yes. So the JPAD in 2020 launched a whole initiative around this, and we made recommendations for how to collect data in a way that would capture the level of detail that we're looking for, but also be comparable across process steps. The one you point to in particular is around how we look at ethnicity versus race. I know we have an increasing number of individuals, I think youth in particular, that when they're asked what race they identify with, they say Latino, and I don't identify as another race. That is what I am. And I think a lot of the state systems and census systems haven't necessarily caught up with that. There are no requirements that folks use the same categories, but Christy has helpfully put our recommendations for what that looks like in the chat if you want to take a look, and we're always happy to talk to folks about that as well.
The census, I'll just add, the census is also, so the federal government is also looking at trying to get some standardization around that specific point, Chris, that you made here around Latino youth. And I believe they're in like an open public commenting period right now. So perhaps more to come on that front.
Got 1 minute. Any last questions? Well, if we didn't get to you, you're going to get the slides. Our email addresses are in there. We're always open to your questions and thoughts. We appreciate anyone that takes the time out of your day to come listen to an hour-long presentation about juvenile justice data. On that list, that means you are awesome to me. So thank you for your time. Thank you for all the work that so many of you do. And be in touch if you've got further questions. Thank you so much.